I was still holding the pen when my son-in-law told me to sign. Not because I was hesitating. Because my hand had stopped working. The way hands are supposed to work when the person you trusted most in the world has just told you, in a conference room with a plate of untouched cookies on the table, that he had been waiting 2 years for this moment. My name is Elaine Beaumont. I am 53 years old. I have spent the last 26 years building a small accounting firm in Asheville, North Carolina. The kind of business that doesn't make headlines but keeps the lights on for 11 employees and their families. I am not dramatic by nature. I don't tell stories for effect, but what happened to me in the fall of last year is the kind of thing that, if I don't say it out loud, I think it will calcify somewhere inside me, and I will carry it the rest of my life without ever understanding what it actually was. So let me tell you. My daughter Paige is 31. She has her father's stubbornness and my coloring, and a laugh that has always made rooms feel larger than they are. She met Donovan Hess at a corporate retreat in Charleston when she was 28, and she called me from the parking lot of her hotel that night and said, "Mom, I think I just met someone who might actually be worth my time." I laughed. Paige had said this before, but something in her voice was different that evening. Quieter. More careful. Like she was trying not to break something by naming it too soon. Donovan was 34 when they met. He came from money the way some people come from it. Not loudly, but with a kind of settled assumption that the world would arrange itself around him. He was in commercial real estate development. Handsome in the way that too requires maintenance, always the first to offer to pick up the check and somehow also the last to actually reach for it. I noticed that early. I noticed a lot of things early and told myself I was being protective in the way mothers get protective. Seeing threats where there were none. They were engaged 18 months after they met. Paige called me from Charleston again, same city, I thought later, same parking lot maybe. And she was crying in the way people cry when they're happy and surprised, and a little terrified all at once. I drove down that weekend and met Donovan for what was only the third time, and he shook my hand with both of his and said he was honored to be joining our family. And I believed him. I want to be clear about that. I believed him completely. He asked me to be a character witness in the spring of that year. It was framed as a formality. His development firm, Hess Callaway Properties, was in the middle of a zoning dispute with the city of Charlotte over a mixed-use project on the south end. A neighborhood association had filed complaints alleging then had misrepresented the environmental impact of the construction to city planners. The case had reached arbitration, and Donovan's attorney said that a respected community member, someone with professional standing and a clean record, testifying to Donovan's character would carry significant weight with the arbitration panel. I am a CPA with 26 years of business in Western North Carolina. No complaints with the state board. No litigation in my history. 3 terms on the Buncombe County Small Business Advisory Committee. I was, his attorney explained, exactly the kind of voice that mattered in these proceedings. Paige asked me herself. She sat across from me at my kitchen table with her hands wrapped around a mug of coffee she wasn't drinking, and she said, "Mom, I know this is a lot to ask." She looked tired. She looked like someone who had been worrying about something longer than she wanted to admit. I told her it wasn't a lot to ask. I told her family shows up, and I meant it. I testified in June. I spoke for 11 minutes in front of a 3-person arbitration panel and said that in my professional and personal experience, Donovan Hess was a man of integrity and sound judgment. I said it clearly and without hesitation because I believed it to be true. The arbitration ruled in his favor 6 weeks later. The project was approved. The neighborhood association's appeal was dismissed. I found out later that the project generated $4.3 million in profit for Hess Callaway Properties in its first 18 months of operation. I found this out from a newspaper, not from Donovan. The wedding was in October. In the mountains, on a property outside of Weaverville that belonged to one of Donovan's college friends. White tents, yellow lights, the kind of evening that looks like a photograph while you're standing inside it. Paige was beautiful. Donovan cried during the vows, real tears, I would have sworn to it, and I stood in the receiving line, afterward shaking hands with people I didn't know, and feeling the particular joy of watching your child begin a life that looks, at least from the outside, like the one they deserved. 14 months later, I was sitting in a conference room at a law firm in downtown Asheville, looking at a document I had not been told I was coming to sign. Donovan had called me 2 days before and said there was a matter he wanted to discuss in person. A business matter, he said. He thought it was better to handle it face to face. He'd scheduled a meeting with his attorney, just to make things official. I asked if Paige would be there. He said no, that this was between us, and that Paige was aware of the meeting and completely supportive. That should have been the moment. That single sentence. Paige is aware and completely supportive. Because Paige had never in 31 years been completely supportive of anything, without also having an opinion about it, that she needed to share with me directly. But I drove to Asheville. I sat down in that conference room. There were cookies on the table that no one touched. An attorney named Whitfield, a thin man with reading glasses on a chain, slid a document across the table and said, "We appreciate you coming in, Mrs. Beaumont. This is a release of testimony agreement." I looked at the document. Then I looked at Donovan. He was sitting across from me in a jacket I recognized, charcoal gray, the one Paige had bought him for his birthday the year before. He was holding a pen loosely in his right hand. The way you hold a pen when you've already rehearsed the next 30 minutes. "What is this?" I said. It wasn't a question, really. Whitfield said it was a mutual non-disclosure agreement paired with a retraction addendum. It stipulated that I would formally amend my arbitration testimony to reflect new information, specifically that at the time of my testimony, I had not been in possession of the complete facts regarding Donovan's business practices. The retraction would be filed with the arbitration board as a clerical supplement. I stared at Whitfield. Then, back at Donovan. "You want me to say I lied," I said. Donovan's expression didn't change. He had a very specific face he made when he was managing a situation. Calm, attentive, faintly sympathetic. The face of someone who had decided the outcome before the conversation started. "Not that you lied," he said. "That you were mistaken. That your information at the time was incomplete." I set the document down flat on the table. "What information was incomplete?" I said. Whitfield shifted in his chair. Donovan uncapped the pen. "There are some matters related to the Charlotte project that have since come to light," Donovan said. "Matters that, had you been aware of them during the arbitration, would have affected the substance of your testimony. The retraction simply acknowledges that gap." I sat with that for a moment. I am an accountant. I have spent 26 years reading documents that are designed to say one thing while meaning another. And I have learned to be very still when I feel the floor shifting under me. "What matters?" I said. Donovan looked at his attorney. Whitfield cleared his throat. "The environmental assessment submitted to the city of Charlotte," he said, "contained figures that had been selectively presented. The firm that conducted the study was subsequently found to have financial ties to Hess Callaway Properties. This relationship was not disclosed at the time of arbitration." I looked at the plate of cookies. Then at the window. Then back at Donovan. "You bribed the environmental consultants," I said. Donovan's jaw tightened, just barely. "Selective presentation of data is a civil matter," Whitfield said quickly, "and one that is currently being addressed through appropriate channels. The purpose of this agreement is to ensure that your testimony, which was given in good faith, does not become a complicating factor in those proceedings." I heard what he was not saying. I had testified to Donovan's integrity in front of an arbitration panel. That testimony had contributed to a ruling that approved a project built on falsified environmental data. If that came out, and it was coming out, that was clear from the way Whitfield was not quite meeting my eyes, then my testimony was not just wrong. It was part of the record that had helped them win. And they wanted me to walk it back quietly before anyone started asking me what I had known and when. "Sign it today," Donovan said. His voice had shifted, warmer now, the voice he used with Paige when he wanted something. "It's the cleanest resolution for everyone. Your name stays out of the formal investigation. There's a consideration payment outlined on page 4. I opened to page 4. $50,000. To be deposited into an account of my designation within 72 hours of signature. I looked at the number. I thought about 11 employees and their families. I thought about 26 years. I thought about the parking lot in Charleston and my daughter's voice, quiet and careful, like she was trying not to break something by naming it too soon. "And if I don't sign," I said. Donovan's expression returned to its managed state. Then the timeline of when you learned what, and what you chose to disclose or not disclose becomes more complicated, he said. For you. That was the threat, delivered in the same tone he used to discuss contractors and zoning variances. Patiently. Without cruelty. Just the mechanism of a man who had learned early that power works best when it doesn't raise its voice. I set the pen down on the table. I had not picked it up. I need to think about this, I said. Whitfield said the offer had a 48-hour window. Donovan said he understood, that he respected my process, that he was certain I would see this was the right path for everyone involved. I drove home. I sat in my car in my driveway for 20 minutes without going inside. Not because I didn't know what to do. Because I was trying to get ahead of the grief that was moving through me slowly. The way floods move, not rushing, just rising. I called my daughter. She answered on the third ring. Her voice was careful in a way I recognized. Paige, I said. Did you know? A pause that told me everything. Mom, she said, her voice tightened low. I only found out last week. He told me it was already handled. He said you'd agreed. I closed my eyes. He lied to you, I said. He told me you were completely supportive. Another pause. Then I heard her exhale the way she used to exhale when she was 16 and had made a mistake she didn't know how to fix. I don't know what to do, she said. I know, I said, neither do I yet. But I need you to tell me everything he told you, and I need you to tell me right now. She told me. It took 30 minutes and by the end of it I had 4 pages of notes in the legal pad. I keep by my landline because old habits are hard to break. Donovan had told Paige the retraction was a formality. That the environmental firm situation was a misunderstanding being cleaned up. That getting my signature was just about keeping things tidy. He had not told her about the $50,000. He had not told her about the language on page 3, which I had read carefully enough to understand that signing would also constitute a waiver of my right to cooperate with any external investigation related to the Charlotte project. That was the piece that mattered. That was what they were actually buying. I have a friend named Cecily Trant. We met in 1998 when she was clerking for a federal judge in Asheville, and I was doing pro bono bookkeeping for a legal aid nonprofit she volunteered with. She is now a partner at a firm that handles white-collar defense and civil fraud cases, and she is one of the most precise thinkers I have ever known. I called her at 8:30 that evening and said, I need an hour of your time and I need it before tomorrow morning. She came over at 9. I made coffee neither of us drank. She read the document in 11 minutes, which I know because I watched the clock. Then she set it down and took off her reading glasses and said, You haven't signed this. No, I said. Good, she said. Don't. She walked me through what she saw. The retraction addendum was not simply a clarification of my testimony. Combined with the waiver on page 3, it was effectively a gag agreement dressed in the language of administrative process. Signing it would have removed me from any investigative cooperation, shielded Donovan from having a credible witness speak against him, and created a paper trail, suggesting I had been aware my original testimony may have been problematic, which could theoretically implicate me in the same cover-up I had no knowledge of. They were not just buying my silence, Cecily said. They were trying to make you a participant. I sat with that. The $50,000, I said. Is not generosity, she said. It's insurance. It links you to the settlement. It makes you a party to the resolution rather than a witness to the conduct. I looked at the legal pad on the table, at the 4 pages of notes from my conversation with Paige. There's an active investigation. Isn't there? I said. Cecily looked at me carefully. You testified in an arbitration proceeding that has now been flagged for potential fraud, she said. The state attorney general's office opened an inquiry into the Charlotte project 3 weeks ago. That is public record, which I found in 40 seconds online tonight. I asked why no one had contacted me. She said witness outreach in these investigations often happened later than people expected, but that given what I had just described, the meeting, the document, the payment, the timeline, it was very likely that by coming to me directly before the investigation reached me, Donovan had done something that investigators would find very interesting. Witness tampering, I said. That is a word that may be used. Yes, she said. I want to be clear about what I felt in that moment, because I think it matters to be honest about this part. I did not feel triumphant. I did not feel the clean, righteous certainty that I think people expect when a story like this pivots toward justice. What I felt was tired. Tired and sad in a specific way that has to do with being 53 years old and realizing that someone looked at your life, your 26 years of honest work and clean record and community standing, and saw a tool. I called Paige back at 10 that night and told her what Cecily had explained. There was a long silence. Then Paige said, in a voice that was very quiet and very old-sounding for 31, "I need to know who he actually is." I told her I thought she already knew. I think that's what had made her voice so careful on every phone call for the past several months. The following morning, Cecily contacted the State Attorney General's office on my behalf and informed them that I had been approached with a document that appeared designed to impede my potential cooperation with their investigation. She submitted a copy of the retraction agreement along with a detailed account of the meeting. The investigator she spoke with, she told me afterward, had gone very quiet in the particular way people go quiet when something confirms what they had already suspected. I did not call Donovan. I did not respond to Whitfield's follow-up email, which arrived at precisely 47 hours after the meeting, reminding me that the offer had 1 hour remaining. I let the 48 hours expire and did not say a word. The formal investigation into Hess Callaway Properties expanded to include obstruction-related conduct within 2 weeks of Cecily's contact. I learned this not from Donovan but from Paige, who was by then staying with a friend in Greenville and had retained her own attorney. There is a particular kind of grief in watching your child's marriage dissolve. Even when the marriage deserved to dissolve, even when you can see clearly that the person they chose had been performing something from the beginning, the grief doesn't care about the logic. It just sits in the corner of the room and waits for the quiet moments, and then it makes itself known. Paige came home for a weekend in November. She slept in her old room for the first time in 4 years, and we made pancakes on Saturday morning. And she didn't talk about Donovan, and neither did I. And at one point she looked up from her coffee and said, "You know what I keep thinking about? I keep thinking about how he cried at the wedding. And I don't know if that was real or if that was also part of it. I didn't know either. I still don't. I think some things you don't get to know." The full scope of the investigation became clearer over the following months. The environmental assessment firm had received more than $200,000 in consulting fees routed through a subsidiary of Hess Callaway in the year before the Charlotte arbitration. The lead consultant had since surrendered his professional license. 2 city planners who had received gifts of value during the permitting process were placed on administrative leave. And the arbitration ruling, the one I had testified in support of, was formally vacated and referred to the North Carolina Bar's Arbitration Integrity Committee. My testimony, Cecily explained, was not the subject of scrutiny. I had testified in good faith based on information I had genuinely believed. The scrutiny was on the people who had put me in that position, knowing what they knew, and then tried to use a conference room and a plate of untouched cookies, and a check for $50,000, to make sure I couldn't be asked about it later. Donovan's legal exposure, last I was told, includes civil fraud claims from the city of Charlotte, potential criminal referral from the Attorney General's office related to the obstruction conduct, and a separate suit from the neighborhood association whose original complaints had been dismissed on the basis of the arbitration ruling he had manipulated. I did not seek any of that. I want to be clear about that too. I did not go looking for his destruction. I just declined to help him escape. Paige filed for divorce in January. Donovan contested it initially, which her attorney told her was standard, a pressure tactic. He stopped contesting it in March, around the same time the Attorney General's office made its findings public. The divorce was finalized in May. I drove to Greenville and took her to dinner. And we sat at a table by the window and she ordered a glass of wine and said, "I don't know what my life looks like now." I told her that was all right. I told her I hadn't known what mine looked like at 31 either. And it had turned out to be something I couldn't have imagined from that distance. She asked if I thought she had known, somewhere underneath it, that something was wrong. I thought about that question for a moment. I thought about her voice in that parking lot in Charleston. The first night she called me. Careful and quiet, like she was trying not to break something by naming it too soon. I thought about the way she had looked at my kitchen table with the coffee she wasn't drinking, and the way she'd sounded on the phone when she said she only found out last week. I think you loved who you thought he was, I said. And I think some part of you has been grieving the gap between that person and this one for a long time. That's not the same as knowing. She was quiet for a moment. Then she said, "How did you know? When did you know something was off?" I thought about the check. About page 3, about the way Donovan had held that pen loosely in his right hand. The rehearsed way of a man who had already decided the room, I said. I think I knew when he told me you were completely supportive. Because you have never in your life been completely supportive of anything without telling me yourself. She laughed. A real laugh, short and surprised, and it made the room feel larger, the way it always had. I am telling this story because I think there are other people who have sat across a conference table from someone they trusted, and felt the floor begin to shift. And wondered if they were being dramatic. Wondered if the instinct that something was wrong was their own fear talking. I want to say clearly, that instinct is not fear. That instinct is information. The way people hold a pen can tell you something. The way someone speaks for another person without asking that person first can tell you everything. I still have the legal pad with 4 pages of notes from that phone call with Paige. I haven't thrown it out. Not because I need it. Just because it reminds me that on the night when it mattered, I did not panic, and I did not sign, and I called the right person. That is, in the end, all any of us can do. Know who to call, and make sure you call before 48 hours run out. If someone used your reputation to protect their own, and then asked you to protect it again, what would you do? And would you recognize it in time?